everyone, and welcome to the second webinar in our series of 3 special webinars, Helping South Eastern Schools Through the Family Law Maze. My name is Karen Akers, Project Officer for South Coast Family Law Pathways Network, and on behalf of the Network Steering Committee, our project partners at the University of Wollongong and the Department of Education, we'd like to thank you for joining us in this webinar, which was made possible by the University of Wollongong Community Engagement Grant Scheme. I'd like to acknowledge the traditional owners of this land across the South Coast on which we are meeting today, and elders past and present. Once again, please note the side on your screen regarding technical matters, and please type in a message Laura at Redback in the chat box if you require any technical assistance. Also, just a reminder to please let us know which school you are and how many people are in your group via the chat box. Thanks. So joining us online right now is John Littrich, Associate Dean, Faculty of Law, Wollongong University. Hello, John.
Hello.
Greg Hand, Student Support Coordinator, Student Counselling and Welfare, Illawarra and South East Region, Department of Education and Communities. Hello, Greg.
Hello, Karen. Hello, everybody.
Wayne Freakley, Chief Legal Officer, Legal Services Branch, the Department of Education. Hello, Wayne.
Hello, everyone.
And here with me, I have Jenny Bailey, Child Counsellor, Family Relationship Centre, and Child and Adult Counsellor for Anglicare, Michelle Wadsaka, Program Manager Family Services and Post-Separation Cooperative Parenting at Anglicare, sorry for the long title, and Carolyn Bateman, Senior Family Dispute Resolution Practitioner. They're all here from Anglicare and the Family Relationship Centre in Nowra. And they'll all be available to take any questions from you at the end of the webinar. So if you think of anything, please type it in into the chat box and we'll get to your questions at the end. So I'll hand over now to Wayne Freakley and John Littrich, who will be getting into some of the nitty-gritty issues that arose from the research in the first part of this project. So over to you, Wayne and John.
Okay, thanks, Karen. John here. Just in case you're wondering, hopefully some of you can see the little webcam on the side. I'm the one in the blue shirt, and Greg's trying to stay out of the picture here in the lighter coloured shirt. I'm not much bigger than that picture in reality, though, in real life. But I'm probably glad that it can't get much bigger than that, to be honest. But just in case you're wondering, as Karen said, my name's John Littrich. I'm the Associate Dean, Teaching and Learning at the Faculty of Law at the University of Wollongong. And before I came to teach at the university, I was a solicitor specialising in family law areas. So what we're going to do today is we're going to expand on some of the things we looked at in webinar 1. Last week, you might remember, we looked at some of the common family law terminologies, some of the concepts, key concepts and principles in the Family Law Act, and we also looked at some of the types of orders you might come across in a school when parents present you with documentation. And we spoke about how important it was to recognise what different orders might do and what area they order covered, whether it was a apprehended domestic violence order or a parenting order or an order in relation to the care of a child because of child welfare proceedings instituted by Family and Community Services. We also touched on some of the key principles from the DEC, or the Department of Education and Communities Family Law in Schools Guidelines. And in the slides from last week, I put up a web link to those guidelines. When you get the slides, you'll have that link, but they're really easy to find. They're on the DEC website and not hard to track down. So what I'm going to do this week, we're going to work through some of the legal and policy positions around particular situations that might arise, in particular using those guidelines so you know what the department, so it's clear what the department's position is, but at the same time bring up some issues at law where there might be a bit of a gap or a bit of a muddy area around some of those particular situations that might arise. So one of the first things I wanted to, I'm jumping ahead of myself. We'll also look, after we've done that, we'll look at some of the services that are available to help parents who have problems, and some of the services that schools might be able to put families in touch with, in particular contact changeover services and also the Family Relationship Centre. And then next week in webinar 3, we're going to actually pick out some specific case study scenarios, so some actual factual scenarios, and work through them using some of the knowledge for this week. So what we're looking at this week, I suppose, we've called the webinar Developing Best Practice. It's looking at the guidelines and at the law with a view to thinking about or developing in your school the best way to approach particular situations so that you're complying with the guidelines and also at the same time making sure that you're creating a safe environment for the child concerned, the other students and the staff at your school. So I'll move on then into what we're going to talk about, but before I do, again, just a little disclaimer up there. This isn't intended to make you bush lawyers at all. As I said on the last occasion, really it's not the role of schools to try and resolve family law disputes. We're just hoping that with this information you're able to perhaps find your way through some of the issues that arise at school easier. So it's more of a guide to assist you in how to work through some of the issues that arise, but it's not expected to in any way have you trained as some sort of family dispute resolution practitioner. Remember, ideally schools aren't the place where family disputes should be resolved. There are other people who are expert in those areas. This is more as a guide to how you can act, what you can do, what you're required to do, or what you shouldn't do perhaps when family law issues arise at your school. And as I've said there in the note, if you do have any issues that arise, check the guidelines and if necessary contact the Department of Education and Communities legal team. Wayne is on the line today and will be speaking shortly, but certainly Wayne Freakley up the office up there, he tells me that they get a lot of calls in relation to these sort of areas and they're more than happy to take your call. So one of the first things we wanted to talk about today was, I suppose, when a child first comes to the school, so the enrolment of the child and the question of who actually does have the right or who's entitled to enrol a child at a school. Well, Part 8 of the DEC guidelines deals with this. And you might remember last week we talked about how under the Family Law Act, the default position, where there's no orders saying otherwise, is that each parent has parental responsibility for the child. So each parent is able to have a say in major long-term issues in relation to a child, and the enrolment of a child in the school is a major long-term issue. So in the absence of any order to the contrary, either parent can therefore enrol a child. And even when orders or parenting arrangements are made, unless those orders specifically take away parental responsibility, in other words, take away the ability of one parent to have a say in these sorts of areas, the default position again will be, or the position that's assumed, if the orders aren't absolutely clear on it, as long as there's no prohibition, the position that will be assumed is that both parents are able to have a say in these issues. And ideally, schools don't want to be involved in these sorts of things. They want the parents to actually come to their own decision together. And indeed, the Family Law Act says that parents are obliged to consult each other and make decisions together on major long-term issues such as this. Now, there's no requirement on a school to establish that the enrolment decision has been made jointly or otherwise, but I think when a child is enrolled in a school, and I've had a look at the enrolment form, which does ask a lot of information about the family law position, it's useful for the school to know the context in which that child is being enrolled and what's happening within the family, so they know if the what the non-enrolment parent's position is. And certainly if there are any orders or arrangements in place, the school needs to know about those, and we'll be reinforcing that message throughout today. So, look, if a parent enrolls a child at a school and the other parent takes exception to that, the guidelines make it clear that the Department of Education's view is that the parent with whom the child lives should enrol the child, and parents can then resolve that issue by mediation or family dispute resolution or through court if they can't resolve it any other way, rather than the school having to act as some sort of mediator or arbitrator in relation to that decision. What if the school is made aware, for example, parents enrolled a child at a school, as I said in the example there, parents have recently separated, one parent moves with the children, tries to enrol them in school A, when in fact the kids are already enrolled in School B, and the parent, who's not trying to enrol the children in School A would no doubt be saying, hang on, these kids are already enrolled in School B, I don't want them enrolled in School A. Well, in that situation, the guidelines say, look, it's a matter for the principal. The principal may allow the children to attend School A in accordance with the Department of Education short-term and part-time attendance policy until that dispute's resolved. But certainly they can advise the parent who wants the kids enrolled at the school that no formal enrolment will proceed until there's an agreement or an order which makes it clear as to who's able to make that decision. So the mere fact that someone might be enrolled in another school doesn't prevent a principal from allowing children to attend at their particular school. Again, it's the principal's call in that situation. It's not the principal's role to try and get the parents to resolve the issue. They should be resolving that outside of the school. But the children shouldn't suffer in that situation, and it's certainly open to the principal to allow the children to attend on a part-time or short-term basis. So, in relation around enrolment, the onus is certainly on the enrolling parent, as I said before, or the non-parent, if it's not a parent with whom the child lives, to advise as to what arrangements are in place in relation to parenting arrangements, and provide copies of any relevant documents, whether they be family law orders, a parenting plan. There shouldn't be a comma between parenting and plan, I'm sorry about that, but parenting plan and apprehended domestic violence order or what have you. I suppose some of the biggest problems arise for schools really when there are no orders in place, or where there is some sort of arrangement but nothing's in writing, or where there may be orders in place but they're lacking in detail on some of these issues. And for example, if there are orders or arrangements which provide for both parents to share parental responsibility, then in the absence of anything in those orders which says, but one of them has say-so of the school, the other doesn't, or what have you, in the absence of that, if parental responsibility is being shared, the school is entitled to assume that both parents have an equal say, and so both parents are entitled to know the enrolment arrangements. And I'll get to that shortly, what that entails. But certainly when a parent is enrolling a child, it's really important to make sure the parent answers the relevant parts of the enrolment form, dealing with parenting arrangements, etc. It's the parent's then obligation to advise if the parenting arrangements change. And the school really needs to reinforce that message. And if you do have a chance to look at the Department of Education guidelines, there's two appendices at the back of it which provide a form of notice to remind parents of that responsibility and the importance of giving that information and keeping it up to date. And I suppose it's important from the school point of view that the parents know who it is that they need to give that information to at the school so it is kept up to date and current. Okay. So when the child is enrolled, there's sometimes an issue that might arise as to what name the child should be enrolled in. Now, a child who's under the age of 18 can't change their own name, and indeed a parent cannot change the name of a child without the consent of the other or through a court order. So, for example, if a parent turns up and says, I want to enrol this child under a name other than what's on the birth certificate, the school's entitled to say no, unless you can provide me with a court order saying the child's name's been changed or some documentation indicating the child's name been changed by way of consent. The school's got to enrol the child under the name that's in the birth certificate. Now, the guidelines make provision for what to do if no birth certificate is provided. And paragraph 9.4 of the guidelines say that a child can be enrolled in a name which the parent says is going to appear on the birth certificate when it materialises. That's allowed, but if indeed when that certificate materialises and that is the name the parent wants to enrol the child under is not the name on that certificate, well, the school has to go with the name that's on the certificate. And the guidelines make it clear that once enrolled, the child will remain enrolled in that name unless there's some court order or a consent to change the name. Witness protection issues or other limited circumstances. And those circumstances are set out in 9.5 of the guidelines. And so if you're in any doubt there as to the parent coming along wanting the child to be known as some other name, then check out the guidelines at Part 9 because they are quite detailed as to what can happen. Now, there's nothing wrong with the child having some sort of nickname or name that they're obviously that's appropriate and that they're happy to have used. There's nothing wrong with that being done. But when it comes to the name they have to be enrolled in, the name they're formally known as, it has to be the name that's in the birth certificate. The birth certificate. Now, I've already probably talked your ear off a bit too much. We're going to move on to another topic arising out of enrolment, and that is, okay, that the child's enrolled. We know that the child's got to be enrolled in the name that's in the birth certificate. Now I'm going to hand over to Wayne just to talk briefly about where one parent wants to have information about where the child's enrolled and what the responsibilities of a school are in that particular situation. So Wayne, are you okay to...
Yeah, sure, John, I'm right to go.
You're in fine voice?
I am, yes.
Okay, I'll hand over to you.
Just to clarify one thing that John was talking about in terms of the short-term attendance arrangements, just note that that is only when the student is enrolled in another government school. It won't apply if the child is enrolled in a non-government school because our policies don't apply to to the non-government system. So in those circumstances, the principal's got a choice of either enrolling or not enrolling.
Thanks, Wayne. I might amend my slide then before it goes out to say, just to make it clear that it applies to government schools only.
Yep. So in terms of access to information about enrolment, as has been said before, the starting point is both parents have equal opportunity and access to the school, including access to information. So in the absence of any court orders, each parent would be able to be told the school at which their children are enrolled. You wouldn't give out any private address details or telephone numbers. You wouldn't give any details of address details of contact people, that sort of stuff, but you can certainly tell the parents where the children are enrolled. Similarly, you could tell a lawyer who provides written authority from the parent that they want that information. That's still okay to be given. Always exercise caution when you're dealing with inquiries over the phone because clearly you can't always be aware of who exactly is on the other end of the line. So you'd want something sent to you to confirm the information that's been given to you over the phone, some email or something in writing that would allow you to objectively confirm that the person seeking the information is a parent and therefore able to be provided the information. The information about enrolment should really only be restricted to the parents. You wouldn't be giving information to brothers and sisters or grandparents unless there's a court order that would allow you to do that. If I could get John to go to the next slide.
Yep, I'll just see that.
Similarly, you'll get requests from time to time from a whole range of agencies, and generally, in just about every circumstance, they'll have some legislative authority for seeking the information. The most common requests are from the police, fax or centre link, and each of them have powers under their various acts that govern their operation that allows them to seek that information, so they shouldn't be concerned about providing that information to them. Or you get ordered by a subpoena or some other notice to produce, in which case, once again, you should be providing the information sought. Gets a bit trickier when there's apprehended violence orders in play because clearly they're issued for the protection of people, and so you have to treat those matters a little bit more circumspectly, particularly if the child is named as a protected person on the order, as opposed to just being in a domestic relationship with a protected person, mum or dad, and they're not actually named. But if there's any suggestion that the child's safety or well-being could be jeopardised by releasing even information about where the child is enrolled, well then you wouldn't provide that, even though all other things being equal, you might do that in other circumstances. So just have to treat ADVO's apprehended violence laws a little bit cautiously. Seek advice from the legal unit here if you're unsure. Certainly, and in terms of releasing information, if the principal believes that releasing information about anything about the child, including enrolment, is not in the child's best interests, then under the privacy code of practice that applies to the department, the principal can consider the best interests of the student, and if he or she believes that it's not in their best interest, well then they can not release information. That becomes particularly relevant when dealing with older students, and in many circumstances the students seek to make those sort of decisions themselves rather than relying on their parents. And whilst there's no magic age about when they can do that, they can certainly, late teens are able to do that, and the principal's certainly entitled to take those views into account. At the end of the day, so long as they're confident that the student's making an informed decision, and it's more importantly that it's in their best interest, well then they can make a decision to release or not to release, and the person who is aggrieved by whatever decision is ultimately made has a right of appeal, a right of review, of that decision to the school education director.
Wayne, just to clarify something, so I'll just go back. Of course, if the school's been ordered or subpoenaed to provide something, the school must comply, but if there's any queries, obviously they'd ring someone like you for clarification.
Yep.
I suppose these other issues in relation to apprehended domestic violence orders and things like that, when I was putting the slides together, I was probably more thinking in terms of the situation where people, other than under a court order, you're being asked to provide information and the need to exercise caution. Because obviously if you've been subpoenaed to produce something to the court,
yep.
Then you can't just say, well, I'm not going to comply with the subpoena.
Yeah, that's right, yes, I'm happy with that. I agree with that.
Okay, I'll just move you on to the next slide then. Sorry, I hope I didn't interrupt you.
Right.
Train of thought.
Just in relation to the releasing of information on the request of students, I just bring everyone's attention to the latest legal issues bulletin, which is on our website, which deals with dealing with students who seek to act independently of their parents. And you'll find a whole range of information there that gives guidance to schools about how to deal with those circumstances, including the release of information or not release of information to parents when the parents want it and the student objects. Similar sort of approach to information held at the school. Again, in the absence of a court order, both parents should be able to access the relevant information. The starting point is that we will send it in the first instance to the parent with whom the child is living. And if the other parent, the non-residential parent, seeks access to that information, then so long as you don't disclose any private information such as addresses and telephone numbers, that information can be provided in the absence of a court order. A court order would need to say that the other parent, the non-residential parent, has no parental responsibility at all in relation to the student. That doesn't happen that often, so in most instances you'll find you'll be providing information to both parents if both parents, well certainly if the non-residential parent requests it, and even more so when there's a shared arrangement and the kids are living equal time between two households, which is not uncommon, then both parents would be getting the information. No need to bog them down with all the the minor administrative stuff like the canteen's going to be closed on Friday or those sorts of operational issues. Though in some instances some parents are insistent that they get everything, and once again, it's a decision for the principal to ultimately make. It's a management decision, but rather than create World War III, it's not really a hill to die on. And if you can reasonably provide that information to both parents without causing an unnecessary diversion of resources and getting it all together, well then sometimes it's better to provide it and put up with a little bit of a hassle that comes with providing all that minor stuff rather than trying to dig your heels in and resist. But once again, management decision for the principal, but there's certainly no obligation to provide that, and a principal who determined they weren't going to would be quite within the right to do so, and the policy would back them up. But so that's just a management decision for each principal to make based on the circumstances of the particular case they're dealing with. And once again, the information we can provide includes, all the stuff that would go out from school reports, newsletters, notices about photos being taken, the school sports carnival, the presentation night, all those sorts of things, student-teacher nights, all that sort of stuff would ordinarily be provided by both parents if both parents have sought access to that information. Similarly with permission notes, we would generally rely on the parent with whom the child spends most of their time. But once again, normally they'll go with excursions, and excursions are fairly significant event in the school, so we would provide both parents with that information if they request it. No need to get bogged down in, having to get permission from both parents. It's quite okay to seek permission from the parent with whom the child spends most of their time. If it's shared and you get a case where neither parent can agree, and it doesn't happen too often, but it does happen from time to time where one parent will object to an excursion taking place, not necessarily because of an objection to the excursion itself. Most cases it occurs because it's at the time when that parent might ordinarily be exercising their contact rights, and by going on the excursion, not going to get that opportunity. At the end of the day, that's a no-win situation for the principal, and all the principal can do is make a decision based on what he or she believes to be in the best educational interest of the student. And presumably most excursions, if not all excursions, should be an essential part of the curriculum in some form or another. So it would be unusual for a principal to make a decision that the excursion wasn't in the child's best interest, but once again, it's a decision the principal has to turn their mind to in terms of that issue about educational benefit. But we don't need to get permission from both parents. That's the main message that comes from that particular issue. John, next slide.
Oh, yep, I'm on. Parental involvement, that one.
Yep. Similarly, getting involved in school activities, particularly school parent-teacher nights. So long as you can be as guaranteed as you can be that there's not going to be any scenes caused or disruption, there's no problems with, subject to any court orders, of course, that both parents are able to participate in those nights. Sometimes we make arrangements where they attend separately. Once again, that's a decision for the principal, but that can be the issue about disturbance and creating World War III when both are in the same room together can be overcome by making those sorts of decisions. But in the absence of a court order, both parents would be entitled to receive that information and participate, because it's about going to issues about their children's education, which is a long-term issue which they're both entitled to have a say in. And of course it's in the child's interest for both parents to be involved in that, and that's reflected in the Family Law Act, which John spoke about last week, where it talks about the child's entitled to have both parents involved in their lives, including their education. Principals need to be education on its own merits based on your knowledge of the circumstance of the family and your history, and you guys will be in the best position to make that sort of a judgment. And once again, if you can't be certain that the peace will be maintained and there is a real risk that it will go pear-shaped if both are on the site, well then you are entitled to make a decision that the parent, the non-residential parent, primary parent, however you want to describe them, isn't able to come at the same time. You might be able to provide the information by other means, but you're certainly entitled to make the decision not to have them on the school site at the same time. Next slide.
Oops, sorry, a lot of it.
Yep. Now the other thing that causes something sometimes is when parents come on to school sites contrary to contact orders. Generally, we will try, if there's a contact order that says that a parent is limited in their contact with the child to certain times, or we will do our best to make sure that at least the spirit of that order is maintained. We sometimes have problems though where families are split and parents have been in other relationships. They've got other kids, other step-kids, and those kids might be attending the same school as their own kids, and so they come to school to pick up their step-kids or their, whatever it might be, and they come into contact with the kids with whom they've got this contact order. Similarly, they might want to come to the canteen and work in the canteen, which means they might have contact with their kids if the kids come to the canteen to order food. The department's approach to those issues is that we regard that as incidental contact, and we don't think that that's necessarily a bad thing. We won't stop parents engaging with the school on that basis alone. If they were to come to the school site solely for the purpose of seeking access to their kids, contact with their kids, contrary to the order, we won't let it happen. But if they come on for other purposes, and as a result of that purpose, for argument's sake, they might be walking across the playground to get to the office of the principal, and in doing so, their kids run up to them and talk to them at a time when they haven't got contact with them. Well, we don't frown upon that. We say that's incidental contact, and that's fine, so long as the parent doesn't abuse the privilege and then extend it on to what a bit longer than what it should be. Just get on with your business, get to the principal's office, get your tasks done, and on your way. Sometimes parents will seek to circumvent contact orders by saying, well, can I participate in the reading program of the school, for argument's sake, and I only want to do a reading program with my child in his or her class. And in doing so, that would bring them in fairly significant contact with their kids. They might even want to read with their kids. And once again, that's might be in breach of a contact order. We say, no, that won't happen. We're quite happy to have you come in and do the reading program, but if you're really genuinely interested in the reading program for our kids at our school, well, you won't have any objection going to another class and doing it with other kids, and that soon sorts out the genuine people from those who are just trying to circumvent the order. So the message to come out of all this is the mere fact that they might have contact of some limited type at the school, going about their ordinary business, engaging with the school, is not of itself an issue that should cause concern, even though the parents might get upset about it. As long as it's incidental contact, we will let those arrangements to continue.
Okay, thanks, Wayne. Obviously, in that situation, as it says in the slides there, it's totally different if there's an ABO or some sort of safety issue, family violence issue around it. Then obviously the position to take is a different one.
Yeah. Well, one thing I just got to say though, it's just important to keep in mind that because a parent might have an ABO against his ex-partner, for argument's sake, and by virtue of that order, the kids are automatically captured by provisions that say that anyone in a domestic relationship is protected from harassment, intimidation, assault and molestation, I think it is, John. I think they're the ones.
Yep. Stalking.
That doesn't necessarily mean that that parent then being on the school ground is breaching that order by talking to their kids. Quite often kids still have ongoing and quite healthy relationships with their parents in circumstances where the mum and dad might not be so crash hot. That of itself is not necessarily a breach of the order. It could be, but not necessarily. So it's not inconsistent for a parent to have an ABO and still be able to have contact with their kids at school, each case on its own merits, each order on its own merits. Similarly, if the order says that the parent is not to approach the protected person's home or work, that doesn't include the school unless the parent works at the school or or more importantly, the school's actually nominated an address where that parent can't go.
However, if the ABA said that not to approach the person
absolutely, yes.
by the order, then obviously, no.
Each order on its own merits.
Okay. Thanks, Wayne. I'm going to move on only because we've got a bit of stuff to get through at the end. So thanks for that. I'm just going to pop back in and talk about another couple of other things, but thanks for that. Following on from what happens at schools, there's some issues also around contact and pick-up and drop-off issues. As Wayne said, some of the incidental contact, but the idea of students using the school as a place to have more time with their kids or to pass on messages or things like that, that's generally something that's not supported, something that's frowned upon, that really the school shouldn't be used as a place for parents to get some sort of de facto contact with their children. But incidental contact, as Wayne said, that's something that is consistent with both having involvement in the child's life. If a non-living parent turns up wanting to see or remove the child, then the guidelines suggest some really useful tips in there as an approach as what to take. So whether there's orders or not, if that situation arises where you know that the child generally lives with another parent and someone's turned up at an odd or unusual time wanting to see or remove the child, whether there's orders in place or not, it's probably important, well, first of all, to check what documentation there is, and if it's going to be some sort of removal of the child, to check with the other parent before that's allowed to happen. A lot of these things may happen outside the school gates, and often there's not a lot to do if you're not aware that it's going on. But if the parent turns up in breach of an ABVO, in other words, if there is an order telling them not to approach the children, for example, or not to go to the school and refuses to leave or is aggressive and threatening, then certainly call the police. Don't put yourself in a situation where your safety is at risk. If a parent takes a child without permission of the other parent, then the parent with whom the child normally is might seek a recovery order, and that might empower the police to recover the child physically and return it to the other parent. And it could well be that the police, part of that is to recover the child from the school. So if the police turn up talking about a recovery order, that's what they're talking about, where the court's made an order empowering them to go and collect the child, take it back to the parent with whom they normally reside. A location order could be served on the school, and that might require the school to give certain information in order to ascertain the whereabouts of the child. And if you're ever worried about what you should do in that situation, contact the DEC legal people. If you're ever asked as a teacher to be a witness, there's no obligation to comply with the request from a parent to be a witness or swear any affidavit. But if you're subpoenaed to turn up or produce records, then of course the school must comply. If you're in any doubt, again, check with DEC Legal Services. If you are going to give evidence, you can only attest to what you can directly observe or record. So don't put yourself in a situation where you're being asked to say things about what you to speculate on certain things. You can only give evidence of what you've directly observed or what you may have recorded. But certainly you're under no obligation if asked by a parent to give evidence. Shared changeover issues, and this leads us into our next part of our presentation, but issues around shared care can often place stress on the child, particularly if one parent's not cooperating, not making sure the gear's there, the homework, the sports gear, etc., or refusing to return the items to the other parent. How can schools help? Well, it's probably good to think about ways, if there are families with two households at your school, is there some way that kids can store gear, bags they're taking to go to the other parent's place, somewhere where they can do that. There's an article, I've given the reference to it in the slides, that you might want to have a read when you've got a time. It talks about schools advising the parent who's being recalcitrant of the negative impact of their behaviour on the child. Probably not a bad idea, but I don't know, you probably want to pick your parent before you waded into that, how they'd react to being told that. Again, it's not your role to resolve the dispute, but if you have an opportunity perhaps to gently reinforce that perhaps the child's been disrupted or upset by these issues, it might be appropriate to raise that. Now, if there is issues with changeover, there are services available in relation to changeover. And Karen, let's throw briefly to you then, because you're going to talk just briefly about some of the changeover services that are available in the southeast area.
Thanks, John. Yes, and we would have had Adam as the coordinator with us, but he's in Bali at the moment, so it's fallen to me. So I'll just tell you briefly what they are. Changeover services are usually government-funded services where children can be transferred between separated parents, usually where there are concerns about violence or high conflict. We thought it was important to tell schools about these services because they're the most appropriate place for transferring care of children who are in that situation, not at the school gate. Having said that, contact services do encourage the use of schools by parents to drop off and pick up by arrangement, especially on weekends. So, for example, an arrangement where mum or dad picks up the child on a Friday afternoon, has them over the weekend and then delivers them back to school on Monday morning, and the other parent collects on Monday afternoon. Idea being that the parents don't confront each other and, importantly, that the school remains that neutral and conflict-free zone for the child. Supervised contact between parent and child can be provided as well. Usually they do that where there are allegations of violence or abuse, or where a child is being reintroduced to a parent that they haven't spent much time with, so there are those very specialised services available. Often parents are ordered by the court to use contact and changeover services for a period of time, but they don't have to be. There's always fairly high demand, and they do often have waiting lists, but it does vary from week to week. The government just recently announced some additional funding for changeover services to help ease some of that pressure. In our region, there is a funded contact changeover service in Nowra run by Catholic Care on a fortnightly basis. There is an intake and assessment process and a small fee, but arrangements are in place for people with financial difficulties. And further south, there's another funded part-time contact changeover service in Maruya, which is run by Mary Mead on Fridays and Saturdays. There are also some other private services. It is a little bit more complicated than that. That's just in brief. But next week we'll have a referral directory available for you that will have some more detail and contact information for those services. And in the meantime, if you would like to know a bit more, you can always call the Family Relationship Centre at Nowra and they can point you in the right direction depending on where you are.
Thanks, Karen. That's a nice segue, in fact, into our next part, and I know we're running a little bit behind time, so yeah, Karen, so we will be releasing a referral sheet document next week, which will have the names and contact details of services in the region in relation to things like changeover and family relationship centres. But as we've said throughout, it's not really the role of schools to resolve disputes between parents. The Family Relationship Centre is one of the key services or organisations available to enable parents to try and sort these issues out between themselves. And Karen's got Carolyn Bateman, who's a senior family dispute resolution practitioner in Nowra, with her down in Nowra today. And she's going to answer some questions shortly. Karen will introduce her and get her to answer some questions, to speak, and then we'll see how we go with questions. But first we've got a short video just about what family relationship centres do. So Laura at Redback, if you could please fire that up. Thank you.
The Family Relationship Centre will talk to all parties involved to help you decide if family dispute resolution is the best process to help you reach agreements. If they don't think that family dispute resolution can help you, they will refer you to another service that will support your needs. You might participate in an education session that will help you to get information about supporting your children. If you go ahead with family dispute resolution, the session can be arranged to make sure the process meets your needs. It might involve both parents being in the same room, a shuttle arrangement where the parents are in separate rooms with the family dispute resolution practitioner moving between rooms, or telephone mediation options. Sometimes your children might be involved in the family dispute resolution. They might talk to a separate consultant who is a specialist child practitioner about their experience of your family separation so that you can make better decisions about arrangements. During the process, you'll be able to decide on issues such as who the children will live with and spend time with, including how holidays and special occasions like birthdays, Mother's and Father's Day will be spent. You can also cover education planning. forward planning and long-term decision-making, finances and child support. Family relationship centres also offer education, support and advice to assist families in building communication and conflict management strategies to support cooperative parenting today and in the future.
Both children go to really good schools and all their friends go there. So I want them to be able to complete their high school education there.
I want that too, so that their lives are disrupted as little as possible. But I want them to live with me and spend a lot of time with me. Because I would hate it if I only saw them every other weekend.
Brendan and Kylie, I'm going to ask you to consider what options you can suggest that might achieve both these outcomes. So Brendan, I might get you to start for us.
Options are generated, progressing towards decisions being made. These decisions will be written up into a parenting plan, which both parents agree to follow. If necessary, parenting plans can be converted into a consent order and lodged with the court at a later date. However, as the plan is supposed to be cooperative, hopefully this won't be necessary. If you think it is necessary, you should get legal advice.
Okay, and look, it sounds as though some people, a couple of people couldn't get any sound there, so I'm sorry about that. It looks as though videos and us aren't being very, last we get a problem with the video, too much sound. Now it looks like a couple of people didn't get access to that. So I apologise for those that couldn't hear the sound on that video, but the video will be available in relation to when you get access to the slides and the recording of the session next week. So Karen, do you want to introduce Carolyn quickly?
Yeah, just again, Carolyn Bateman's the Senior Family Dispute Resolution Practitioner here at the Family Relationship Centre in Nowra. And we've just invited Carolyn to tell us a bit about the centre that's here on the South Coast. Carolyn?
Hello everyone. I'm aware it's running a bit late, so I'll keep this fairly brief. At the Family Relationship Centre, the bulk of our work involves working with separated parents. Family relationship centres were set up by the government with the understanding that parents should be able to work out what's the best arrangements for their children rather than fighting it out in court. So we mediate with separated parents to help them work out care arrangements. Our process is neutral, so we don't support either parent. However, we can support both parents equally through the process by ensuring that they have all the information and support that they need to be able to make arrangements for their children. What is utmost for us is that we keep the focus on the children and what the children's needs are. Geographically, we have offices in Nowra, Ulladulla, Maria and Bega. We have 5 family dispute resolution practitioners, a child consultant and Indigenous service advisors who can support Indigenous clients through the process as well. Parents can self-refer themselves here or be referred to us. Our service is free for those earning an income under $50,000. If they earn over $50,000, it's $30 an hour after the first hour that's free of mediation. Part of our process is a psycho-educational group that parents attend, and that group talks to them about conflict and the impact that conflict has on them and their children. And then parents are given skills to be able to develop what we call a cooperative parenting relationship with the other parent. And Michelle Wazaka from the Post-Separation Cooperative Parenting Program will talk more about that next week. We work collaboratively with other services to support parents through our process, including the domestic violence services, community legal services. We do a lot of referral for parents to counselling, anger management groups, legal services, parenting groups, anything that will help them to be in a better place to better parent their children. As I said, our process is neutral, and as mediators we can't take sides, but we can be advocates for the children. And we encourage parents to put the best interests of their children first when they meet with us to discuss care arrangements. We also can encourage agenda items. So when there are school-age children, we encourage parents to talk about how they're going to communicate about the school and with the school. When parents want to use school as that changeover point, we ask them to think about how this will work for the children. And we certainly are always talking to them about keeping conflict away from their children and particularly away from school. We do talk to them about the importance of being involved in the school life of their children and whether they are able to attend school events. We can't make decisions for parents, but we really reality test them around the decisions they're making, around how this will be for their child. Jenny is our child consultant, and she is able to meet with children in several different capacities. At times she can be involved in the mediation process, in being a strong advocate of the child and bringing their voice and their needs into the mediation. She also runs therapeutic groups for children who have experienced separation, and Jenny will be speaking more about that next week and how you can refer families to that group. The other thing that we're working on at the moment is a form. At the moment it's called a school plan that parents can come to the centre to talk about, that can then be given to the school, and it will give the schools information around what sort of parenting agreement is documented, where changeover happens, correspondence, who will get what, about fees, enrolments, reports, newsletters, excursions. When there's disciplinary issues, who gets notified about that. And then specific arrangements for parent-teacher interview, absentees, school portals. And so that form will hopefully be worked on more over the next coming week and be available for you next week. It's something that we will use in our mediations. We'll encourage parents to fill out that form in a mediation to bring to school, or parents may be able to come specifically to us to get that form filled out. So that's all the information I have, and if there's any questions, I'm happy to answer those.
Okay, thanks very much. Carolyn, yes, so John, if you want to do a quick wrap-up for us, that'd be great.
Yeah, just quickly then, there was just a couple of questions along the way. One of them was about a copy of the PowerPoints. You are going to get a copy of the slides, and you are going to get a link to a recording of the actual sessions. And just there was one other question that was asked, was what age can a child decide who they want to live with? Well, there is no magic age. What you find though is the courts become more reluctant the older a child gets to make an order that is inconsistent with the views expressed by the child. The views of the child are one of the things that the family court or the Federal Circuit Court has to take into account in a family law matter, but the older the child, the more weight is likely to be placed on that. Courts don't like making orders where they know that a 16, 17-year-old child is just going to vote with their feet. But there is no magic age. Generally, once a child reaches 15 or 16 and is expressing a clear view one way or the other, or there's an order they live with mum but the child keeps running off to dad's, mum keeps going back to court to get an order trying to enforce it. As long as dad's not interfering with that, the court's not going to want to really be making orders that a child has clearly said they're not going to abide by because they don't want to live there. So yeah, that's about as best as I can do to answer that. But once a child turns 16, of course, they can. There's very little that can be done in terms of what they want to do themselves. Although family law orders operate until the child's 18. What have you said? Well, generally, one last question. Who would generally be responsible for reporting to the school if children are removed from family? Okay. If community services remove the child, then they would generally serve the school with relevant paperwork so the school knows what's going on. If a child has been placed with a foster parent or a relative or someone like that by virtue of family and community services getting some sort of care order, again, that parent should produce, or that foster parent should produce the relevant documentation to the school so the school knows what is going on there. And again, if the police are removing a child from the school, they would generally, the school would want to see some paperwork before they simply allow that to happen. And try to make sure it all happened in a context which causes as least distress as possible to the child. Any other questions, particularly of Carolyn or Wayne?
Yeah, we have Jenny, child counsellor, Beverly, domestic violence person from the YWCA, Michelle, an Aboriginal service advisor. So any questions for those ladies before we finish today? Last chance? No? Okay. All right, thanks everyone. Yes? Yes?
There's a question there. Who should contact the school if a parent is put in jail? Well, I suppose it's difficult because as to who, there's no rule as to who should contact the school. If mum was the enrolling parent or the live-with parent and she's jailed, then obviously she can't contact the school and confirm that. I imagine some other family member will. There's no automatic hierarchy. If mum goes in jail, there's no automatic default position that child lives with dad. But if the child, for example, was living with dad and there was some other relative that had a problem with that, they can go to the family court or the federal circuit court or the local court indeed and try to seek some sort of order preventing that from happening. But if a parent is put in jail, it's really up to, I suppose, someone else in the family or someone else to let the school know what's going on. There's no law that says a particular person has that responsibility.
Okay, was that the last question? So we should probably wrap it up and say thank you to everyone for your participation. There were some great questions. Thank you very much to the panel and to the presenters. And please join us for our last webinar next Tuesday, June 18th, 4 p.m. And if you wouldn't mind, just please take a moment to answer the 4 questions before you log off. That would help us out. So thanks very much again, and bye till next week.
Bye.
Bye.